Morning, everyone. Hi. Thank you all for coming to this important seminar that has been kindly proposed by Pandora Mather-Lees of Art and Superyachts and Holly Piggott of Alinea Customs. Those of you who don't know, my name is Adam Prideaux. I work at Hallett Independent. We're brokers, we look after galleries. We love being involved in these kind of events because although there are insurance implications from the changes to this act. Actually, we're very grateful to have Chris Bentley here from Axa XL, who's also supporting the event and will join our Q&A. But what we really enjoy as brokers is giving out this information and informing you. I mean, being an insurance broker, we're arranging insurances is easy and getting the lowest premiums, but it's how we differentiate ourselves from our competitors is just precisely by getting involved and informing you and the trade in general about these kind of changes. What's significant here is that if you understand them, and you are greatly improving your risk management for your business. This is a bit like when AML, that they've grown, the upset, but these regulations are not going away. You would improve and get as much training as so. We're going to do, Pandora, you're going to talk first, then Holly, then we're going to have about sort of 10 past 10, some Q&A. But I think it's fair to say, if you want to ask questions during the talks, then put your hand up and ask away. And there's supposed to be more questions you ask. Thank you all again for coming, and over to you.
Thank you. Good morning, everyone. I hope you're all coffeed up and ready. I'm Pandora of Art on Superyachts. I'm a founder member of the Art Due Diligence Group, which helps people with fine art transactions. You may have heard of us. And also not just to help with those transactions, but to help when things go wrong and there's needing to be a litigation process or a fraud. And there's about 9 of us members in that group, of which the large part of them are lawyers. I'm not a lawyer, I'm an art historian. But I do own Art on Superyachts, which is a training business. And that business is specifically for captains and crew and pursers and yacht management to assist them with understanding art history, art appreciation, because if you don't know what's around you, you can't look after it. And the practical care of art, art management, and then legal export risks. So this presentation, which is very much abridged for purposes of just getting through this morning, is one of the modules of my course, which is endorsed by the University of Portsmouth, and it's a certificated course. So very much focused on yachts, but also applicable, obviously, to household management or anyone that needs to understand about the art world. So as Adam said, and thank you for the introduction, and thank you to AXA Art and to Hallett for sponsoring this. As they said, there are going to be 2 presentations this morning. My presentation is a broad overview because there's quite a lot of complexity around this legislation, and law for me as an art historian is a very dry subject and quite impenetrable. So I'm going to give a broad overview, and then Holly is going to do the sort of very practical side because she's an expert in the customs area. She's dealing with customs issues every single day, so she will talk about that. So I will come round and start talking. Effectively, we're talking about 2 regulations here. There are a number of regulations that affect the art world. We all think it's an unregulated marketplace, but Pierre Valentin, who some of you may know, who's an art lawyer, said there are about over 300 laws governing the art world and transactions. So I think we got quite enough of them, and here's 2 more for you as well. Regulation EU 2019-880 and its sister act, which is 2021-1079. This is the protocol for EU for registering its legislation. The first is the original law, which was passed as law in 2019. And the second is the implementing regulation, which is how it's actually going to practically be implemented. So that's mainly what Holly will be talking about this morning. It's only now coming into force because obviously if you try to get all the European countries together to agree on a common framework, it is complicated. So that's why. Yeah, so the first thing to explain is that the regulation is an import regulation. So you guys are presumably all based in the UK, you're trading out of the UK, you're exporting into other countries such as Europe. So you have to think about the fact that this is an import regulation where the importer has to do the work of bringing the objects into their territory. The second thing is you have to think of the EU as a single territory, okay, as a single border. So that's how this is being treated. So it's the first thing to sort of get your head around. And the other really important factor of this is that the UK is not part of this regulation. Okay, the UK government opted out. So that is good, and it's also bad because it means as the UK is opted out, there is no free movement of objects, obviously, between the UK and Europe. So there is going to have to be protocols that will. This has been driven by the Syria conflict and conflicts in the Middle East. So I often call this talk that I do looted antiquities or conflict antiquities. So it's sorry, clicking. There we are. So I don't know if any of you have seen these scenes of destruction. This is the museum in Mosul in northern Iraq being pulled down by the iconoclasts of ISIS, Islamic State. And then here, the Palace of Ashurnasirpal II that goes back to the 9th century BC. For any of you antiquities people here in the room, again, being destroyed, these beautiful Lamassu winged creatures that used to guard the palace. So this goes back to 2015, and scenes like this obviously make us question, you know, what is cultural heritage, how important it is. This is an attempt to strip us of our collective memories, of our identities, our sense of belonging and our past, and to impose a new regime, the Islamic State regime, and new loyalties to that regime, and to wipe out what went before. So it really is a testimony to how important the work we do is in the art world. So just one more scene, a sort of introduction of this. Looting is as old as the hills. You've got the tomb robbers in Egypt and things that have been going on for a long time. So why is this law being passed now? Well, this picture you see on the right-hand side was one of the triggers for it, along with the UNESCO 1970 convention. It was one of the triggers because you can see here in the inset, the Temple of Baal in Syria, in pretty good nick for an ancient monument, and then destroyed in the main picture at the top. So this goes back before, you know, quite a long way to the Arab Spring. There were a lot of uprisings, as you may have realized. Then we had 9/11, the Taliban being sought out, new geopolitical cultures emerging, and all of these uprisings sort of created opportunities for people to go and loot objects and smuggle them out. And this is not good because it's now come to a point where it's almost crime on an industrial scale. So what's happening is that goods are sourced and sold to fund terrorism. So looters, who are often quite displaced people, they're trying to feed their families, and sometimes, you know, they're in war zones. They are being given a license, or they were given a license by ISIS. In this example, I'm giving you, obviously it's happening all over the world, but in this example, given a license by ISIS They had to, if they sold the objects, they then had to give 20% of the funds and the proceeds from that object to Islamic State. And what did they do with that? They used that money to buy guns. And what do guns do? They kill people. So this whole aspect of organized crime, art, drugs, guns, sort of all comes together in one respect. We have seen a vast increase in selling these objects on Facebook. Okay, I've had some slides of that, which I took out for purposes of not being too long this morning, but they are being sold on Facebook, and there is even looting to order. So these goods come out of, smuggled out of Turkey, they end up in bric-a-brac shops, tourist shops, dealers' shops, and then they go into owners' homes, and hopefully mostly unwittingly, but sometimes these things are looted to order by people. And here on the other side, just to prove the point, you can see some ancient sculptures with the tag Islamic State flag tagged around them. So this is another example. So these are really catalysts for the adoption of this regulation. And it is quite draconian. So that's why we've got this little introduction to explain to you. So I'm sorry if this slide is a bit hard to read, but I'm still going to go through it. So this is why this law is really quite strict. And it does mean that the EU borders are now going to be subject to very strict and stringent border controls because of this. So collectors, owners, shippers, people bringing artifacts into the EU, you're now going to have to prove legitimate origin. It's creating the need to conduct really fundamental and in-depth provenance research on all the items that might fall into these categories. So there is some good news in fact that this regulation does not apply to EU indigenous artifacts. Okay, so anything that was sourced or discovered in the EU does not apply. So if you're shipping a Monet painting, for instance, whatever the threshold value, if you're shipping it into the EU, you don't have to worry because it's seen as being sort of repatriated. So you know, any European EU country, you can, if you've got documentation to prove that it is a Monet and it's French, you can bring it into any European country without having to observe the protocols. Okay, so there are three main categories of artifacts which apply under this regulation. There's Part A, Part B, and Part C. And Holly is going to reiterate what I've said and give you a bit more in-depth information. But just to give you the overview, Part A is sort of freshly excavated artifacts and a whole other plethora of artifacts and objects that broadly relate to the 97,000 tariff codes, the customs codes. Okay, so those objects, if they are prohibited from being exported from their country of origin, if they're prohibited objects under the national laws of that country, you cannot bring them into the EU. It's just verboten. Okay, so that's the first thing. So for the purposes of what we're doing today, practically, we're ignoring that because you can't ship them anyway, it's illegal. Okay, so we're going to be looking at parts B and parts C. So part B is effectively archaeological artifacts, icons, statues, parts of monuments, underwater monuments too, because remember, a lot of our cultural heritage is underwater. There's thousands of wrecks, you know, just in UK waters, and so there's a lot of artifacts there. That's another of my modules, actually. So any of these artifacts that are over 250 years old will trigger the need for you to have an import license. Okay, a license that you will have to complete, which Holly will be explaining, to import into your member state, which you're bringing your goods into. That license can take 90 days. So that's really important because if you're selling something to someone within an EU member state and they want it now, as everybody does when they buy something, you're going to have some issues potentially. Okay, so you need to bear that in mind, that this is not a quick a quick transaction necessarily. The other thing is you're going to have to prove legitimate origin from the original country. So imagine that you've got a dealership and you're selling an Egyptian shabti sculpture or ornaments or whatever it might be. If it's over 250 years old, you're going to have to prove that it was legitimately exported from Egypt. There are derogations to that, but that's effectively what the law says. Okay, so, and that is classed in the legislation as a third country, and you would be the country of interest that is moving it onwards into the EU territory. So we'll deal with that a bit in a minute, but then part C, just to deal with part B and part C. Part C is all other artifacts that relate to the 97,000 tariff codes. So we're looking at paintings, sculpture, drawings, that sort of thing. And so with those categories, there is a different threshold. It's not 250 years, it's over 200 years. Plus, if it's also over 18,000 euros, then that is going to trigger the need to conduct your due diligence to bring the artifacts into Europe. Okay, so 18,000 euros and over 200 years old. Here, you will also need proof of legitimate export from the original country to prove that it doesn't fall into the Part A illegal category. And you will also need to complete an importer statement. You won't need a license, but it will be a declaration that the importer will make and sign. Whoever is importing will make a declaration and sign it based on, obviously, the information that you're going to give them and the research that you've done. Okay, so there's going to be need to be a means to control all this and manage it. And so there is a system within the EU that's now been developed, which is going live in a couple of days, which is called the ICG system. And that system is an import of cultural goods electronic system that largely sits on top of the EU traces software system, which is really for agricultural objects or agricultural we might call them, but it's the agricultural, it's another part of legislation, but it is being used to house this and sort of support this particular type of import protocol. Okay, so the other thing to mention is that customs officers will be trained to monitor the borders. There is an additional EU legislation actually, which is related to strengthening the borders, because obviously you might be thinking, well, we'll find the weakest border point and try and import our goods through there. It may not be the most tax efficient border point, but it's another issue. But they will be trained to actually monitor what's coming in, and they may ask questions if you're submitting a license or a declaration to try and understand further more about the object. The EU has imposed that the customs officers in the member states will pass law to make sure that penalties will be imposed, and they're deterrent penalties and they're criminal penalties. Okay, so it's going to trigger criminal penalties. So if you're caught bringing something or moving something across a border and you haven't declared it at all, it's smuggling, okay, like CITES, National Treasure regulations. And if you declare something and you change what it is, and it's not exactly what the actual object is, so you're trying to fudge it to get it through, that will be a false declaration, and so that's also going to have a criminal penalty for that. So it is quite important to do your best to get one's house in order. So that seems quite draconian in one respect it is, but there are some derogations, and there are derogations for scientific research, education, conservation, digitization, restoration and certain exhibitions, and also for collaborative research between museums and cultural institutions. I think for the purposes of this, the museums and the cultural institutions are seen as trusted parties, so they just have to make a sort of general registration within the system, and they're pretty much a lot more freedom than the rest of us in the room who are obviously trading and selling works of art objects. There's also a derogation for storage and warehousing as a refuge. So if there's a natural disaster, like an earthquake, or if there's a conflict, and goodness knows we're seeing a lot of that this week and all the time, and goods need to be moved to house them for safeguarding, then that's another reason that they can be brought in. And obviously we've seen that with the Ukraine war, that Russians have destroyed, are destroying their cultural heritage. A lot of museums in Kherson were looted, and so obviously that is something that's being done at the moment. Okay, so there is also a sort of get out of jail card, which is a 5-year rule, which I think Holly's going to talk about a bit more. But if you are exporting your Egyptian shabti from the UK, and you can prove that it has been in the UK for 5 years, you've got some documentation around that, then you will be able to make a declaration for application for a license, and that will be considered. And you may be asked some more questions, but then you should be able to move the object in through the EU. So it's a 5-year rule, and that is obviously quite important. And that will be from the country of interest. So you would have to declare that you cannot find the original export license. It's no good trying to get a retrospective license, because for the past 30 years, we have all been, all the countries in the world want to repatriate their objects. So there's no way Egypt is going to issue a retrospective license for your object that you put across. So that's obviously a no-no. There are some other aspects connected with partage and a regulation from 1972, which is UNESCO, which Holly will talk about, where you can also get a bit of a get out of jail card. But effectively, that's the essence of the regulation. I think it would be quite useful to just mention art fairs, because I'm sure everyone's obviously thinking about art fairs. We've got Treasure House this week rather, and we've got a number of fairs. So obviously you currently work on a TA system, and you will be allowed to work through this on a TA system for art fairs. But there are sort of some rules around that. It has to be a public fair, it has to be public access, it has to be advertised, it has to be sort of fairly well known and meet certain criteria. You can't just bring it into someone's house and say, well, it's being exhibited there, it's a TA, whatever. So you have to be aware of that, and Holly can talk a bit more about that. But you will still need to make a statement, an important statement. So I've talked a bit about enforcement. Does anyone know about the ICOM Red List? Has anyone heard of ICOM? ICOM is the International Council of Museums. So I've attended their conference in Korea. They're really, really interesting to join. They do a lot of work. They have a lot of projects around the world, really responsible for understanding objects, cataloguing them, having a shared understanding and means of classification of objects. Now, ICOM has produced, since the year 2000, I think it is, a number of red lists. These are hot potato nuclear items, which were sort of 17 countries. It's now 20 countries and probably growing. And they're objects in danger of being looted. The items you will see in these red lists are actually from museums, but they're guidance for law enforcement and for customs officers to look for objects that might be potentially stolen or looted, and to stop this trafficking, basically, because ICOM is responsible for cultural heritage as much as other organisations. So yeah, they're particularly vulnerable artefacts as well. So it will never be definitive. There will always be more that could potentially be added, and indeed new countries might be added. So it's good to keep an eye on any country that might now have a red list. Ukraine is one of those more recent ones. There is now an ICOM red list for Ukraine with their types of objects that are particularly vulnerable. and the Balkan countries have recently been added as well. Okay, so that's a bit on law enforcement. And then just to touch on some other legislation, I think Holly's going to mention this too, so I won't go into too much detail, but there's the Hague Convention of 1954 and 1970, which was sort of enacted in 72, which is critical for us. There's now about 137 countries signed up to the Hague Convention. It's the International Criminal Court. It's managed by UNESCO. I'm sure you all know about it because you're all working in the cultural heritage sector. But this is registering property of high importance. There's about 2,000 sites worldwide, but 55 of those are of particularly high importance. And more recently, they've been working on civil and military partnerships. You may have heard of the Blue Shield emblem, maybe. The Blue Shield initiative has had a lot of vision and visibility in the art world, whereby trained sort of art market participants perhaps will go into some of these conflict zones and other zones, and they will try to tag items with a Blue Shield emblem to say, you know, these are vulnerable objects and they must be looked after and protected, and also documenting them. So any of you that know anything about conservation, one of the agents of deterioration is lack of documentation. So it's this aspect of documentation that's so important to help preserve objects, to be able to understand them, know what they are, and to be able to protect them. So civilians are being trained in self-defense, and also they're trying to use a lot of new technology now to support. Because obviously we've got technology, so it can be deployed. And do they have any teeth? Well, there has been the first conviction in 2016 that related to the mausoleums in Timbuktu. So yes, is probably the answer. And yeah, the 1970 convention is particularly important, which Holly will come to. So this begs the question, you know, what should I do as an owner of art? In my case, owner or yacht manager of a super yacht. You know, what can we do to avoid getting caught out and to do our due diligence? Well, first of all, you need to understand what is in your collection and review your portfolio, and really to be aware. And you need to conduct provenance research and document your collection. So part of that review should be current valuations. So valuations are really important because obviously items on the art market fluctuate up and down, driven by auctions and all sorts of other things. But basically, you know, valuations will be important here. And also, I have seen something within this legislation that said it should be signed by an expert. And even if it's a valuation from Christie's or Sotheby's or an auction house, that valuation should come from the expert themselves with their own stamp. Well, good luck to all of us with that, because no one wants to put their name to something like that necessarily. But that was what I read. Yeah, anything bordering on the €18,000 mark that falls into the Part C category is really important, because obviously currency fluctuations could trigger a need to engage with the protocols. Obtain the ICOM red lists, which we've done for you. So we have a lot of helpful reference material, which we've got, which you can email us for and we'll send it to you. So we've got all of the red lists in a folder for you. Understand the cultural goods definitions, which Holly will go through and which we also have for you in a folder. And understand how an object will be interpreted for customs purposes. Your CMS management system, your content management system, or that of your client, or that of the people that you're dealing with that are importing the objects, should be up to date and have all the items that might trigger this regulation flagged. And obviously your SOPs. So SOPs, if you work with family offices or yachts, are the standard operating procedures. It's the Bible for managing the household or the vessel. It's got health and safety, the manuals. It's basically your manual. That should be flagged up. There should be an art related aspect to that. Copies of documents. I think Holly's got a list of potential documents. They should be traveling with the object and available in an official EU language. English is obviously pretty important. I have seen super yacht captains fall foul of giving customs officers who come on board documentation in a language they couldn't read, which incriminated them. The object was taken away. So have to be quite careful that people you're working with really understand and have things in the right language. Prepare your own statement of origin and import a statement for the goods. If you do it now and get going with it, then you're going to be well in advance. And have proof of dates when things moved around. Okay, so try to track it a bit like a passport stamp. You know, with France, a lot of times when they're moving goods in and out of France, you need a passport stamp for the object. I'm sure you're familiar with that, but really try to keep a good track of this. And record anything, obviously, of 5 years residence in the country of interest, the country that you're exporting. Be aware of countries you're trading with. So some people might be trading with a particular jurisdiction where its own national laws will obviously come to play. And so be very cognizant of that. And then train all of your staff. Everything. So it's great that you're all here, but you'll probably go back to your galleries and there'll be people there that, you know, just don't know anything about this. If you've got one weak link in your organization that ships something when other people are on holiday or whatever and they don't know what they're doing, it could be a pretty bad career limiting move. So it's really important. When I've trained on yachts and, you know, crew rotate, I've been brought in for the training week and I'm conducting this to half the crew. And then, you know, the second half come back off rotation and they're expected to just, you know, understand whether sort of hand over document or the notes that I've left behind. And so it's not really ideal, but really make sure new staff coming on board are trained as well. And then I should say that regulation is not just, this regulation is not just about ownership. It's not really about ownership. It's about the legality of the object itself, whether that object is licit to move. But having said that, you know, if you've got title and title insurance, that might come into play, but the insurers will perhaps add to that a little bit, but it can only support you essentially. And the other thing to say about this as well is that for insurance purposes, if you have smuggled, say, something across the border and you are caught doing it, and then the object is confiscated. There was a situation with a super yacht where a Picasso was confiscated by the owner. They picked him up in Corsica and they took his Picasso painting away, but that's good for you all because you can go and see it in the Madrid Museum, but he no longer owns it. He was given a fine and a jail sentence, but in that case, you won't be able to claim for that object on insurance because it's an illegal act. So you're not covered for anything that you do that is illegal. So that's it really. This is the email address here that you can email us, or we will have our contact details in your packs anyway. If you would like a wide range of resources, including the red list, the categories, electronic copies of the forms, and then also legislation and some useful articles if you're interested to read around. So that's my part, and now I'm going to hand over to Holly, who will give you a lot more detail than I can about the specifics. Shall I let you set up? Yeah.
We're at the Lansdowne Club today. The Lansdowne Club was created in 1763. The architect was Robert Adam. And if anyone has an interest in political history, I recommend that you go downstairs to the Adam room, which is outside the courtyard. And you'll see the room where the Treaty of Independence was signed. And there's a very interesting cartoons on the wall, which were the equivalent of journalists' photographs side. And you can see the British party didn't want to be photographed, so there's just the Americans signing Treaty of Independence. It looks like there's half missing. So I'm Holly. I'm director of Alinea Customs. we're a UK customs brokerage. We're partnered with Art Services, which is part of Group BBL in France. And so we can offer your clients registration on the Traces portal for access to the imported cultural goods system, customs clearance end-to-end between the UK and France, temporary storage facilities in Calais, and access to a free port in Paris. Art Services have around 20 years experience in fine art and linguistics. So the learning objectives of today's presentation to understand the implications of Part A, Part B, and Part C of the EU Cultural Goods Act, understands customs classification using the EU tariff database, and customs procedures and the registration process on the imported cultural goods system. And also, if you take a look in your handbooks, there is a paper document with the importer license and the importer statement data set. So it will be an electronic document that you will have to complete, but all of the basic information, all of the data sets you need are on those sheets, A4 sheets. Also, it's important, I don't think anyone's mentioned it yet, to mention that there's also a requirement for photography. So the importer license and importer statements, they require specific photographs that from specific angles. And Oliver, our photographer here, was also specialised in art documentation, so it might be useful to speak to him. So let's look at the issue and the legal framework. So as Pandora's mentioned, the legislation has stemmed from the implications of the UNESCO Convention 1970, particularly Article 6, which requires 147 members which have ratified the UNESCO Convention to enforce through their domestic legislation the requirement to enforce the export laws concerning cultural heritage goods from all of the member parties to the UNESCO Convention. And that's fairly unusual. So we would rarely ever see nations enforcing external jurisdiction. We would only really see that within an arbitration agreement. So it's quite unusual. Within the UK context, it's enforced through the Dealing in Cultural Objects Offences Act 2003. So as a customs agent, the director of a customs brokerage, I've seen the UK legislation enforced on quite an indiscriminatory basis, and we've seen clients' goods entering from Jersey or from trusts in external regions be quite unnecessarily held up at the border. So at least there's some predictability in terms of the EU's enforcement. Most importantly, it's important to remember there's a general prohibition rule concerning any cultural objects which have been illegally exported from their country of origin or country of interest. Then Part B, the requirement to apply for an import license for cultural, particularly archaeological finds, which are over 250 years old, regardless of their value. And the Part C, which probably applies to more people in the room, which is a requirement for fine art and prints, old books, if they have a value above 18,000 euros and were created prior to 200 years ago, to apply for an importer statement. And it's the importing party that must apply for the importer statement. The risks are civil and criminal, and the risks will be enforced. The penalties will apply at national level in interaction with the EU member states' domestic legislation. So what is the Cultural Goods Act? The regulation establishes rules for imported cultural goods into the European Union. Its purpose is to combat illicit trade, particularly linked to terrorist financing, tax evasion, and money laundering. It's quite a global first. It will be the first government-organised international database of high-value art and antiques. It's not accessible to the public. Only government authorities will have access to the information contained within it. But it won't just be used to enforce cultural heritage. legislation, I believe that they also intend to exchange data with regards to money laundering and with regards to players in the art market. So from the 28th of June 2025, which is on Saturday, all imports of art and cultural goods within the regulation scope must be registered through the EU's new single trade window, the import of cultural goods system. So firstly, let's take a look at Part A. Part A covers all cultural goods which have been illegally exported from their country of origin, and this includes rare collections and specimens of flora, fauna, minerals and anatomy, property relating to history, products of archaeological excavations, elements of artistic or historical monuments or archaeological sites, objects of ethnological interest, paintings, pictures and drawings produced entirely by hand, original works of statuary art and sculpture, engravings, artistic assemblages, old books, postage and revenue stamps, archives, and articles of furniture more than 100 years old. Now, it's interesting to know just while this is quite a large and definitive list, this really covers the export regulations in the country of origin with certain derogations. And interestingly enough, furniture and ceramics, which whilst they might be covered by this list, they're not included in the requirement to apply for an importer statement. So Part B of the regulation, as Pandora's mentioned, this covers products of archaeological excavations and elements of artistic or historical monuments. And that also includes liturgical icons and statues. And then Part C, of the regulation covers cultural goods, which is more of a cultural goods including rare collections and specimens of flora, fauna, minerals and anatomy, property relating to history, antiquities such as inscriptions, coins and engraved seals, objects of ethnological interest, objects of artistic interest such as pictures, paintings and drawings produced entirely by hand on any support in any materials, original works of statuary art, original engravings, original artistic assemblages, rare manuscripts and incunabula, old books, documents and publications of special interest. And for these, the importer must provide an importer statement, which includes a declaration confirming lawful exportation from the country of origin. So, as a derogation, as Pandora's previously mentioned, there's two specific derogations from the requirement to prove that the cultural good has been legally exported from its country of origin. And the first would be whether the country of origin is indeterminable, and that has to be proved by an independent expert. And the European Union suggested that an expert from an auction house could be relied upon, their opinion could be relied upon to provide that expert opinion. Or alternatively, there must be proof that the cultural goods were taken out of the country in which they were created or discovered prior to the 24th of April, 1972, which was the date when the 1970 UNESCO Convention came into force for all members which have ratified it. So it can be either or. There's either the obligation to prove that it's been legally exported from its country of origin, or to prove that it's been legally exported from the country in which it's resided in the previous 5 years, but it must be proven that it was exported from its country of origin prior to 1972. So, as a compliance matrix, perhaps consider 3 specific questions. Was the cultural good exported in compliance with the laws of its country of origin at the time of export? Or will the trader rely on the 1972 derogation in which case was the cultural good exported in compliance with the laws of its country of residence for the most recent 5 years. And the UNESCO does have a database where you can enter the country of origin of the item and enter the time period or specific year that you are seeking information on. And it will provide you with a list of access to documents concerning all of the laws that were in place in that country concerning cultural or heritage objects at that point in time. So it's probably a good place to start. With part B, with regards to the archaeological excavations, if an import license is required, there's some other, from a legal perspective, in terms of a contract of sale, there's some other points to consider within an international contract. So lots of international sale contracts are either conducted on an FOB or a CIF basis. So if we consider a cost insurance freight contract, the seller would cover the cost of the insurance, the freight to a point of destination, usually in the buyer's country, and the buyer would cover the import declaration for customs purposes and the application for an import license. So whilst normally we would think that a CIF contract, most of the responsibilities are on the seller, in fact, if the import license is rejected by the European Union, the buyer would then have probably quite considerable risk because they would have an item in another country which they're not actually allowed to import into their EU member states. So I think there's probably some impact on contractual arrangements to consider, and also who covers the storage obligations within that time period. So the European Union have a 21-day time frame in which they can ask for additional documents related to an import license. And then once they've if they don't ask for any additional information after 21 days, you can assume that they're processing your import license. And they have then a 90-day window in which they can either refuse the application or approve it. And then this brings us to part C. Is an importer statement in accordance with part C required? And if it is, then it's important to ensure that an appropriate document set is provided to your client, the importer, and that they've also made arrangements to register for traces in the imported cultural goods system and employ a customs agent perhaps to do that work for them. Customs agents are permitted to have intermediary access to the imported cultural goods system. Generally, we've found with common health entry documents, which are currently used for traces for goods covered by sanitary and phytosanitary controls, and that would be plant, products of animal origin, honey, animal byproducts. They're generally a common health entry document can be applied for up to 30 days in advance of import, and we would expect to see the same with importer statements. So I would suggest you ensure that your client applies for the importer statement before you ship the goods, rather than the goods have to potentially be held at the border. Storage costs, particularly if you're sending goods by air, are really expensive if the goods aren't collected after the first 24 hours. Storage charges will escalate, and they'll escalate if the goods have to be collected. Whereas with shipping, you might have 5 days before demurrage would apply. Most goods entering the EU from the UK will arrive by road, and they'll use the Calais, Folkestone, Dover, Calais, Folkestone, or Folkestone, Calais route. So the EU tariff database specifies specific commodity codes for cultural goods. Generally, the UK and the EU have harmonised our commodity code nomenclature with a few variations from the EU side. So the standards, we would normally expect to see a 10-digit commodity code for imports and an 8-digit commodity code for exports. But there's certain, if the EU has extended that to 14 for certain cultural goods which have a provenance of Persia or Syria. And there's interestingly, there's going to be some changes to the tariff nomenclature published from the 28th of June 2025 to accommodate the changes. So I can send details out probably on Monday or Tuesday once they've been published, if anybody's interested. So heading 9705, which is the first 4 digits of a commodity code, covers paintings, drawings, and pastels executed entirely by hand. And heading 9702 covers original engravings, 9703 original sculpture, heading 9704 postage and revenue stamps, 9705 collections and collectors' pieces of archaeological, ethnographic, historical, zoological, botanical, mineralogical, anatomical, paleontological, or numismatic interests. And heading 9706 covers antiques of an age exceeding 100 years, or indeed exceeding 250. And all of items which fall within these categories will be subject to customs controls when entering the European Union. And it will be the responsibility of the importer to declare the correct information or claim a legal waiver from an exemption from customs controls. And generally that's done by just informing your customs agent that your products are exempt. The delivered duty paid, DDP Incoterm, which is generally used when shipping to private individuals, will present a complexity simply because companies, organisations or individuals in the UK cannot register for the Traces NT system because they can't be the holder of the goods. And so it's only organisations which have a permanent establishment in the European Union that can act as the holder of the goods. The European authorities do permit the differentiation between the owner of the goods and the holder of the goods. And what they have suggested is to appoint a customs representative or a fiscal representative or an agent who's willing to take responsibility for acting as holder of the goods. And if you look at the forms, you can see clear differentiations between the owner and the holder on the form to permit that. So you can use, I'm sure there'll be a secondary market, as I was discussing with Chris earlier, around the legislation where we'll see an increased amount of financial products offered by probably banks and institutions, and also different fiscal representation in it. And also that brings us to also discussing what to do with regards to art fairs, because really importantly, an ATA card can no longer be used. Now, I think I should probably flag that if you go to the London Chamber of Commerce and request an ATA carnet for goods covered by the scope of the regulation, they won't decline it because the UK has they probably won't even be aware because the whole application process is electronic. So you can get an ATA carnet for these goods in the UK, but if you take them into the European Union, there will be a significant risk that you could be falling foul of the EU regulations and your goods could be seized and penalties could apply. This also represents some significant financial risk because instead of using an ATA carnet, you will have to use the temporary admission procedure. So this will require an appointment of a company or organisation to act as holder of the goods and use the Traces NT system. And they will have to put down a customs comprehensive guarantee against the import VAT value of the artwork whilst the goods remain in the European Union. Obviously, the member states have different rates. For artwork in France, it's 5.5%. Italy's just changed their VAT for cultural goods to 5% from 2022, and Hungary has maybe 27%, I believe. I've just brought up some specific, I won't run through all of these, but if it's relevant to anybody, there's some details on the screen. Their goods are of Russian origin or Ukrainian origin, and there's certain veterinary controls over cultural goods containing animal products. So these are the specific commodity codes which are covered, which are relevant to Part B, the requirement to apply for an import license. And as I've discussed, and I anticipate this is probably, there's going to be an addition additional 4 digits appended to the 10-digit tag nomenclature. Currently, for goods originating in Persia or Syria, there's these 4 additional codes, which makes the 10-digit code into 14 digits for goods originating in Persia or Syria. We work with several auction houses that have trust or dealing goods from trust from various European nations and Jersey, and we often see these are the most likely type of goods to cause issues at the border. And there's again here printed maps more than 200 years old, which might be relevant. So I thought I'd briefly reflect on examples of cultural goods. So as a general prohibition rule, looted items from Syria, Persia, Egypt, and Libya, specifically conflict zones, would be covered within the scope of Part A, as Pandora's mentioned. And here we would see stone carvings, pillars, capitals, and friezes, ancient columns or temple facades, ancient manuscripts and religious texts, and art and cultural goods that require an export license if that license has not been granted. And then Part B, the high-risk rule, covers archaeological artifacts, ancient pottery and ceramics, figurines and statues over 250 years old, for example, a Roman bust from Syria or an Egyptian sarcophagus, metal artifacts, mosaics, frescoes, stone reliefs, such as a stained glass window from a medieval cathedral in the United Kingdom. And then Part C, which is the low-risk rule. So the criteria is the object must be over 200 years old and valued at 18,000 euros or above. Antiques above 200 years old, and for example, an 18th century literary work at 200. And there'll be a significant intersect with the Export Control Act 2002 and Export of Objects of Cultural Interest Order 2003 for exports of relevant goods from the United Kingdom. So this is just a screenshot from the Traces website, so you can see what it looks like. It's currently used for issuing common health entry documents for goods covered by sanitary and phytosanitary controls. Non-EU economic operators cannot register directly on it. Instead, they must consider the appointment of an EU-based representative. In order to register, individuals or organisations will require an EORI number. So there's in France, there's a service called Soprano. I've just put the website address here. And if you are a seller selling to a private client in France, your client, I would advise to direct your client to this web address and to follow the instructions. Do you file with a SIRET number and then complete the fields of the EORI request. Now, the addition of an attachment will be mandatory. The scan of an identity document or any document proving the operation, such as an invoice. And for greater readability of the application, the individual or non-professional may add a comment in Soprano indicating their request for an EORI number is made as part of an import license or an importer statement application. And these are the instructions for your customs agent. I appreciate that these are quite technical. We would generally expect customs agents to be aware of them, but if you have a specific broker and handled these type of goods before, lots of customs agents will be also learning the system. Now, I just received this was sent by the French government yesterday to our partner agent. So the code for your customs broker would be L049, and then you'll have a unique reference which is issued when the import license is granted, or L050 for the importer declaration. Again, there would be a unique document reference issued once your statement is granted. And then there's 3 waiver codes. There's 4 actually. So there's, if your goods aren't subject to the controls and your customs agent is stuck and doesn't know what to do, you could perhaps suggest maybe your goods are covered, you think they might be covered by Part C of the legislation, but their value is only maybe €10,000. But your customs agent might be struggling to actually process the declaration. There's these 3 different waiver codes here which can be used, and they're generally only, you can only use them with the authority of the consignee, the person acting as the importer. And then the customs agent will also have to put the code Y235, which identifies that the cultural goods have been lawfully removed from their country of creation or discovery. So in terms of planning for temporary admission to art fairs, this should integrate the appointment of an EU-based representative, and for this party to act as holder of the goods. And they would also have the legal responsibility for any declarations that they make on the portal. An ATA carnet can no longer be presented as an alternative to a C88 declaration. And the special customs procedure, which is known as a customs procedure code, it's a 7-digit code on the C88 form, for temporary admission by customs declaration or by permanent authorization must be used. So if you import an agent or a fiscal representative who doesn't have a permanent guarantee account, they can then put a security deposit with the government, the import VAT value of your goods, and use the temporary admission procedure alongside the import of cultural goods statement or license application. If you're working with an established organisation such as Christie's, you have permission, they can provide you with access to their permanent guarantee account for permanent guaranteed temporary admission, and the import VAT value would be lodged as a liability until the goods are re-exported. So traders should consider the local rate of VAT in the importing country, as this may have to be placed as a guarantee. And VAT rates on cultural imports vary across member states. For example, Italy is 5%, France 5.5%, Germany 7%, and Hungary 27%. And there's probably just some significant financial implications which will spring up when shipping these goods to relevant art fairs. And perhaps there'll be some banks and financial institutions that will be able to provide some products to assist with this. I think there will be a strong secondary market, as I mentioned. So this brings me to the end of the presentation. So just as some points that we've covered, so specifically valuation, cultural goods, books and antiques created prior to 1825 and valued above €18,000 are covered by the scope of the legislation. It would be advisable to probably at least integrate a 4-month window for any import license to be approved. UK traders should make arrangements with EU counterparts to register on the ICP system and direct their clients, their private individuals, to register for an EOI number and register. The ICG can only be used by entities with an establishment in the EU. Traders may appoint an indirect representative who's established in the EU and would act as holder of the goods on the ICG system. And also something that, just to mention, that there's going to be some variations in between border points. So currently, we've been informed that Belgium will have specific entry points for cultural goods, which will be designated border offices. And when entering Belgium, there will have to, the goods will only be able to enter through routes where there's these specific customs control offices. So, yeah, as I mentioned earlier, I would really recommend for all of these data sets in the A4 handout, I would recommend to put the data into an Excel file with a heading for each of the categories, and then to enter the data in your inventory or that you're shipping to an art fair in an Excel file format, because customs agents tend to use Excel files because we can easily manipulate the data and cut and paste it. And there's also different systems, API integrations, which makes it quite a bit quicker. Whereas if it's all put on a PDF document, there'll be an element that it would take longer to take the data, and possibly people will be copying it rather than cutting and pasting it. And finally, a document checklist when exporting goods to the European Union. This is the definitive list on the left, which is published in the guidance. And then I've just put some additional information on the right. So the published guidance states customs documentation providing evidence as to past movements of the cultural good, insurance documents, transport documents such as a CMR, airway bill, bill of lading, and collection and delivery notes, property titles including notarized wills or handwritten testaments declared valid under the laws of the country where they were established. Declarations under oath of the exporter, the seller, or other third parties, which were made in a third country and in accordance with its laws, testifying as to the date on which the cultural good has left the third country where it was created, or other events supporting its licit provenance. Expert appraisal, publication of museums, exhibition catalogues, articles in relevant periodicals, auction catalogues, advertisements and other promotional sales material, and photographic or cinematographic evidence which supports the legality of export of the cultural good from the country of interest. And then in addition to this, I would suggest obviously an export license where relevant, the appraisal of an independent expert, and it must be signed by them, a CAT res, identifying provenance and due diligence archives, art market dealer, high value money laundering supervision, proof of registration as best practice, and also proof of the valuation method for customs purposes in circumstances where no sale has been made. The WTO has specific guidance identifying it must be valued for customs purposes in accordance with method 2.6. And that brings me to the end of the presentation. So if you have any questions later, please present them to me and to the others in the panel. And I'd like to say also thank you to the sponsors here today, Hallett Independent and Axa.
Wow. Thank you, Holly. That was one of the most enormous amounts of information and such a detailed presentation. It's really appreciated. I see quite a lot of blank faces. I don't know about you, but I am, I think, concerned about this, if that's the right way to frame this. But thank you. We haven't got much time, so let's get straight in to some questions.
I'd like to, sorry. Certainly the UK opted out of being part of the EU body first. Do you know if Switzerland opted out as well, or Switzerland's being part of the EU?
In Switzerland, it was fine.
Okay. And the second part, is there going to be kind of a folder as such, kind of kept online of if you've had something approved for a license once, so you won't need to apply again, or you're going to have to apply for the same item repeatedly if you imported it into the EU more than once?
So that's a slightly grey area at the moment. There's a recommendation if an item is sold to apply for a second license to clearly document who is the current owner of the goods, but it's not enforceable in law at the moment.
And you would have the record, wouldn't you? The
Yeah.
number, so you would have done that work once, even if you had to reapply. Because
George, go.
Thank you very much for that. I wonder how we are going to base the valuation of this €18,000. And I know I mentioned the example, we have an artist who makes modern sculptures, but he will use antique broken pottery. So although the maybe Japanese pottery he will use is valued at maybe £200 to £300, the actual sculpture itself, and it's broken, the actual sculpture that we would be selling could well be over £18,000. You know, where are they going to draw the line? Is it going to be on the value of the total sculpture or the value of the component parts?
it's a difficult one. I mean, I'm thinking about CITES here. So I'd seen a situation once where there was a picture with a frame imported into the US, and the dealer said that it was ivorine frame, and the US importers thought it was ivory, so it would infringe CITES. And in fact, it turned out to be a mixture of two, which is really sort of the same thing that you're talking about, but the object was confiscated. So it's a difficult one. I don't know how to treat that, but I think if you wanted to be safe, you might declare it.
I would suggest if there's an underlying trade agreement, so for example, if the goods are being exported from the UK to the EU, look at the product specific rules of origin, and they will identify specific criteria for that commodity code from its integration of external materials. There's various different. It's of this question often comes up with manufacturing, obviously, and there's if to look in the product specific rules of origin, if it's UK origin, and you'll see that how much external components can be used in a particular object to make it of its essence.
Chris, would you just say a few words about the insurance implications?
Yeah.
Without, just in brief as possible.
Essentially, the sort of headline is that pretty much all insurance policies will exclude state confiscation or temporary deprivation. So if you have something impounded or confiscated, that will not be covered by your insurance, as all insurance products are today. There are several limits to what we can do as well. So we can't really insure you for sort of some kind of criminal breach that leads to redress against you. We're not allowed to. So any sort of penalty will remain uninsurable. However, what I think we might be able to do as we sort of see how this process crystallizes, and I think, I mean, I still have a huge number of questions about how this is going to work in practice, I have to say, as I'm sure pretty much everyone in the room does. But as we see that the sort of precise nature of how this is going to play out crystallize, I think we might be able to start offering some sort of cover for example, costs incurred in trying to get an item back in the event something is impounded, as long as you've sort of gone through a certain process that tries to minimize the risk of that happening. So that's something we'll look at, over the next 6 months, year, in conjunction with Hallett and indeed all of you. I think there's another area which is of some interest, which is that if you're going to seek a third-party opinion that allows you to obtain the necessary documentation, if that advice proves to be deficient in some way, and you have a loss or you are temporarily deprived of something, you would, in many circumstances, have recourse against the person that's given you that advice. That is a double-edged sword, however, because I think that will that exposure will limit the number of people who are prepared to give this kind of advice, and they will probably charge fees for that because they will be taking on an additional legal exposure. So I think I am very interested to see how the sort of industry for providing the necessary paperwork develops as these laws sort of become more embedded. As far as I understand, even you as dealers won't be able to provide an opinion yourself. Is that correct? Even though you are experts, that was something I was going to ask you.
I think it's that again. It's a slightly grey area. So there's an EU issued Q&A, frequently asked questions, that was published on the 17th of February 2025, and I think they will accept verified, established independent experts and independent experts affiliated with an auction house, and that's the two different expert criteria. I guess
Sorry, Juno, but it was literally such a fundamental misunderstanding of how the market works,
Yeah,
trade works, because you're not going to go into auction houses to get items valued, and it's just a travesty thing.
And I mean, sorry to pick on you, George, but yeah, I mean, you will trade in certain things that you are really the leading expert on. So how can you go and get a third party opinion on value? And
Does it sound like they're using the French auction model as a basis where you have the auction houses, but they will employ specialists kind of outside of that? Yeah,
that's interesting. Interesting. Yeah.
Possible, because there are increasingly no experts left in any of the auction houses. I mean, that's the end of that.
What is, I'm probably asking more questions than I should be, but what is an expert? How clearly defined is that? And also, when you're sort of being given a valuation that establishes whether you meet a threshold or not. On what basis are you conducting that valuation? Is that probate valuation? Is that market value? Is that double high auction estimate, etc.? I mean, it's that I can see a lot of cultural goods being imported into the EU worth 17,500 euros. Honestly.
Can I ask?
I read an article in the art newspaper, Pierre Valentin, who suggested that the legislation, the drafting of the legislation is flawed in that the derogations provided by it are ineffectual.
Yeah.
The rest of the legislation kind of militates against them. So you think you're safe because you've got this 5-year derogation, but in fact it's not the case.
I read that as well.
Right.
The intersect between the Part A and the Part C.
Yeah.
Yeah.
So you can't be too careful, and that you can't trust the legislation to make sort of sense you'd expect it to.
Even cultural heritage lawyers trying to interpret this, saying this seems to be going around in circles, so it is difficult.
Right.
I think the only good thing that may come out of that there may be some leniency at the beginning, and there may be a need to tidy up the regulations to make them clearer. Obviously, it was drafted. I mean, I was very much in touch with Daniel Dalton, who was the MEP in the UK at the time, responsible for working on this, along with Alessia, the second name, it was an Italian MEP. And this regulation should only have been about archaeological antiquities, conflict antiquities. And she somehow managed to sway, everyone in the room to make it about a wider section of cultural goods, and it's completely wrong. There are other laws governing that already. So it will be difficult. It's not tested, and we don't know how this can act to try.
Ollie, you mentioned that there's a portal, I think UNESCO, where you can insert date information associated with an intended import.
Yeah.
And that will tell you whether the date that you had, the early date that you had, is pre or post applicable legislation.
So
Would you be able to send us a link to that? I mean,
of course, do you have a card? That's like a your card out for your event, and I'll send details.
Can I ask what position something in T, something that's been included in a TA? Will this legislation apply to that?
Anything in Part C. So if the goods are sold whilst they're in the EU, then they have to be imported into circulation and account for the window fee.
So, but they become Part C at the point of sale to a buyer.
Yeah. So once they've moved from exiting temporary emission procedure and into recirculation, Part B goods which have been imported into temporary emission will then apply.
yes.
On the back of that, I don't understand then why things on carnet would also be affected. This we ship both with a carnet and on TA according to what we're doing. By definition, items on a carnet need to come back after 3 months or 6 months. So why include items on a carnet if they're going to come back to the UK anyway? And that's why, it just doesn't make sense.
Yes, because it's a booklet and it has leaves which the customs authorities stamp stock 24 when they exit and at the once they arrive. It's a paper booklet. It's not a customs declaration per se. So ATA carnets can't be used because the customs declaration requires those specific codes like the L49, the L50 code, accompanied by the document issued by the ICP system. And that has to be presented on a CATA deck. And so the ATA carnet is just a big document. It's not a declaration. So those codes can't be put on the ATA carnet. The fees.
Thanks, George. You possibly summed it up.
Thank you all.
Thanks.
Thank you.
Do we ever get that?
Not anymore.
Well, what I was asked does anyone know any of this? Is this all familiar to anyone? Or is this all new to all of you? I mean, hands up, just as a sample, you know, you actually knew that there were some changes ahead, or was this going to be? So you're kind of a little bit of an idea. I mean, it does speak to the fact that the art world, the trade is often behind on these regulations. I mean, this is what happened with AML. There's always a lag. I can't help but think that what you've got to do, it's a bit like us in insurance. We get changes to regulation that say after Brexit, we weren't able to do any direct business with our European clients unless we had an office that had some kind of were regulated in Europe. Been recently changes to Swiss insurance laws where you have to have an office in Switzerland or be a regulated Swiss insurer to be able to look after Swiss domicile. It really affects our business. I mean, we lost a huge amount of clients. We had to reorganize our business, restructure it. And, you know, I just implore you to embrace this, get some training, you know, make sure you've got someone in the business who knows this inside out. So you don't get caught out. And it's a hit to the bottom line because it is, you know, you might well decide not to, you know, bring goods in and out of the EU. It might change the way you focus the dealing. Thing is, don't get caught out. It's not going to go away. That's the problem.
Let's make another point, I think, with AML. It was on to us being the seller, right, to make sure to do our due diligence. This is slightly different because, you know, we have, you know, buyers set in the EU, and they're often just private clients who have no idea. And so it's actually it's them, they need to actively also know all this stuff.
Yeah.
How, if we are not clear, how are they have any clue?
So you're absolutely right. So it is also about, you are the conduit to educating your clients as well.
Is it really our responsibility as art dealers?
It's probably not entirely.
You know, where does one draw the line?
It's not, but I think that I think of a good example. It's a bit like, you know, cyber, the risks of cyber. Like, you all know that there are risks associated with doing business online and emails, and you can sort it out yourselves. But actually, when you start telling your clients that you're sending documents in a secure way, you're helping them. So you don't have an obligation, but I think it will help your business a lot if you find a way to sort of condense all this down into a you know, a short to the point document that seeks to explain it.
As you mentioned in the sort of readmission system, what happens after the fair when the piece is sold or not? If we want to bring it into the EU, does it need to go back to the UK and then apply for the import license? Or can it say in the...
It's a good specific for archaeological
Part C?
the same way you would just be using the temporary admission procedure. So you would then ask the customs agency to conduct a procedure called pre-circulation. So they would close the temporary admission procedure and import the goods into pre-circulation, at which point, if you place the deposit for VAT against your temporary admission account, you would receive a refund that those funds would be after about 3 weeks. And at that point, the person who's purchased your goods would have to pay the VAT to the European Customs Authority. So you would receive a refund and your importer would have to pay VAT.
And you'd have to have an import statement.
Exactly, yeah.
So that's
so they would be you have your importer statement, the TA, and then your client would also have to submit an importer statement for their import entry, because they would then be the owner of the goods.
So you have to apply for the import statements prior to the fair. So 2 days before the fair.
Yeah, you would have to appoint
But that's a license, not a statement, right? So for part B, if I'm following correctly, and I might not be, but for part B, you need a license. That's what takes potentially 90 days to obtain. For Part C, you just need an importer statement, which is a sort of attestation.
Yeah.
You can, there's no sort of you're the provider, or rather your buyer is technically the provider of that, although in practice, I'm assuming you're going to have to spoon feed that importer statement to your buyer in order for them to comply with the legislation.
What I would have expected to see is some of the art fairs giving out guidelines on this, on what prospective exhibitors should be doing, the kind of timeframes they need to be doing. Because our experience is that often galleries don't decide what they're taking to fairs till the very last minute. This is going to require a lot of organisation advance. And if art fairs want to continue to have business from, you know, outside EU clients, they're going to need to help, because this burden will deter people from showing.
So if you take something to an art fair in the EU under temporary admissions, and then you sell it to a buyer outside at that fair, do you still have to briefly import into the EU and comply with the legislation? But then you've made the sale in the EU, even though it's to a buyer in, say, the US?
I think you would just do an export out of TA, and then your procedure would be closed, but would have to, then the goods would have to be shipped to the US and perhaps stay in a temporary storage facility until they're shipped.
Okay, yeah.
Okay, well, we've reached the sort of end point, so I don't know if one last question, or shall we call it quits?
Presumably UK produced goods like a Reynolds from the 18th century, Reynolds portrait from the 18th century is not considered an EU origin item, or so if it's a British portrait of 1800, whatever it might be, this applies to it.
Yeah, thank you all for coming. Obviously, if you want to follow up with any of the panel here, then the contact details. All it says thank you for coming, and good luck with all of this.